technological companies are actually facing, and they should take up such projects as their research work during their M.Pharm. Your invention should be non-obvious, of course, and it should have economical significance. All this is to be proved over the existing technology. That will prove your inventive step, making it a patentable asset. So the problem you have identified, you have developed a solution. The way to arrive to the solution is patentable. So congratulations, you have got a patent if you have covered all these hurdles. So problem solution approach to arrive at an inventive step. Solution must be non-obvious to the person skilled in the art. Like in Hindi we say, ये तो कोई भी कर सकता है. That factor should not be there. For that, again, it requires presentation of your idea before the patent controller in a very lucid manner, because this objection may come that it is very obvious to the person skilled in the art to do. But again, if it is so obvious, then why for 80 years nobody thought about it? That is the counter argument to that objection. And it is a subjective creation, of course. Now, this is a very nice illustration to explain what technical solution to a technical problem, how it can be proved as an inventive step to get a patent. Now, earlier, suppose this is some random example which we have kept here. So earlier patent process, this is a process basically wherein these three ingredients were required to produce a pharmaceutical intermediate, which is again that pharmaceutical intermediate is again used to create some very good anti-cancer molecules and other drug products. So earlier patented processes which were there, it utilized the raw material, that is 1-bromo-3-chloropropane. The quantity was 315 grams. Methyl acetoacetate, 250 grams. It utilized potassium carbonate in the quantity of 560 grams and water 1.5 liter, that is 1500 ml. So the product which was obtained using these ingredients was 250 gram and effluent was 1900 kg. Now some company came along with a very good process. Now you'll be surprised to see that they have only replaced potassium carbonate with sodium methoxide. You may see the content of sodium methoxide here, which is very less. So 160 gram sodium methoxide can do the job of what potassium carbonate did with 560 gram. So your raw material reduced, so your costing reduced. Product output is same, but effluent generation is reduced. So 450 grams of effluent generation is there, which is very much less as compared to the prior art processes. And in this process, the solvent which is produced can also be used for further batches. So these are the inventive steps of this invention as compared to the prior art, which has made this invented process a patentable process. So when the young innovators, they think that their project can be patentable or they want to make their project patentable, they must look upon their research work or project work with regards to the inventive step, because according to me, the first hurdle is novelty, no doubt, but the biggest hurdle is the inventive step, which has to be kept in mind before going ahead with the invention process or the research project. Now, industrial applicability, the invention or your innovation, whatever, should be capable of being reproduced through an industrial process into a finished product or essential intermediate of a product. It can be, established by analyzing the field and subject matter of the invention, market analysis for use in industry, and technical use of the product. So your invention, if it may sound very novel, it may sound promising, but if it is difficult to be executed through an industrial application in the company or a factory, then your invention fails on the aspect of industrial applicability, and your chances of securing a patent over your invention will be far less. Now, before you go ahead of thinking that I have got an idea, because as the title of our presentation says that what components should be kept in mind before going ahead with the new idea. So, but whether your idea falls under the patentable invention or not, that has to be checked first before you start your project work. So there is a list of factors or rather characteristics which do not fall under the patentable invention. So suppose your invention, if it get covered under the listed field of inventions, they are not patentable. Frivolous inventions, inventions which are contrary to law. Now, I don't know whether everybody must have heard of perpetual machine is something, many of the students have come up with such projects wherein the machine will not require any energy. By way of perpetual motion, it will keep on working, but that is again in contradiction to the, established laws of motion and laws of nature, because such machine, though in the mind of an inventor or an innovator, it may seem to be a very good idea, but practically it is impossible to achieve. There cannot be any machine which can perpetually move or perpetually work, hence such inventions are not patentable, which is contrary to public morality or order. Suppose you invent a gambling machine, terminator gene technology, such ideas are not protectable under Patent Act. Mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or discovery of a non-living substance. Something existing already in the nature and you say that, sir, I have invented this, that will not be patentable. I think I must mention one very good example of a case named Diamond versus Chakravarti. I don't know whether the students may have heard of it or not. Mr. Chakravarti was a very renowned scientist in US. He developed microorganisms which can eat up oil and related substances. So as per this provision, microorganisms are not patentable. But those microorganisms were developed in the laboratory. They were not derived from any natural sources. They were developed to solve an industrial problem. So the problem of oil spillage in oceans could be cured by using those microorganisms. If you spill those microorganisms in the ocean, they will eat up all the oil, and that can solve so much problem, right? And the company said that it is not patentable. The Mr. Chakravarti said it is patentable. The matter went up till the apex court of US, and it was held that it is a patentable invention because it is not something, these microorganisms are not found in the nature. They are artificially made, and they really solve a very good problem regarding environmental concerns, and hence patent can be granted to such an invention. So section 3D says that mere discovery of a new form, as I earlier said, the Novartis case, Glyvac was the brand of the anti-cancer medicine, imatinib mesylate. Imatinib was already given patent in 1993 in India, but Novartis said in 1998 that they have developed a new form, the new salt of imatinib, which is imatinib mesylate, which is more efficacious, more bioavailable than the earlier salt. And the matter went till Supreme Court, and Supreme Court said that this is nothing but evergreening of patent, and that cannot be allowed in India, especially where patients, they cannot afford expensive anti-cancer medicines, and the patent was revoked, and imatinib mesylate patent was cancelled. So just by saying that one enantiomer or another crystalline form is more efficacious, yes, if it really is has a good efficacy as compared to the earlier known salt, you can get a patent. Otherwise, no. Yes, substance obtained by mere admixture. So very good example, very known, well-known example is of Combiflam, paracetamol plus brufen. So both are known substances. You will not get patent on Combiflam. Solution of sugar and color to make a soft drink. It is just an admixture. Very obvious. You cannot get patent over such things. Mere arrangement or rearrangement or duplication of known devices. So when I say that XYZ API was given through nasal drop. I am proposing to give it through nasal gel. Very obvious. You are just arranging and rearranging the things, not patentable. Method of agriculture and horticulture, cultivation of algae, preparation of improved soil, it is not patentable. Medical, surgical, curative, prophylactic, diagnostic, and therapeutic treatment or treatment of animals are not patentable. Plants and animals as a whole, varieties and species of seeds. For that, basically, there is a separate form of IP which is called PPVFR, that is Plant Protection Variety and Farmers' Rights Act. Under that act, you can get your newly produced breed of plant or animal, or not the animal, the plant or the seeds or any such species. Those varieties can be registered under this act, and you get protection over the said species for a limited term. Recently in Gujarat, Lay's, which is a very well known potato chips company, filed a suit against bunch of farmers in Mehsana district under PPVFR Act, wherein Lay's claimed that it had secured registration under this act for a particular variety of potato, which was used to make chips. And those breed were cultivated by farmers in Mehsana without authorization, and they filed a suit against the said farmers in Gujarat. Any mathematical method or business method, algorithm, or computer programs. So as I earlier said, computer programs or softwares are something which are subject matter of copyright, but eventually uh, by the guidelines on computer related inventions in India, now computer programs are also patentable in India, but it should have some technical advancement or economic significance or both as compared to the earlier known technology. So if your computer software or program solves some problem associated with the earlier known technologies, then it is very much patentable in India. Any literary, dramatic, musical, or artistic work, aesthetic creation goes under copyright, hence cannot be protected under patent. Presentation of information, like right now I am doing, this is not something which is patentable. Topography of integrated circuit, for that there is again a special statute, a special act, which is Semiconductor and Integrated Circuit Layout Design Act, wherein you can get your integrated circuit registered and get the protection. Haldi, Avla, all these things are already known. We know it has a very good immunomodulation effect. It increases your immunity. Hence, you cannot get a patent over such things. Now, once you have identified what IP does your proposed project covers, your invention may be pertaining to a device that has a very unique shape and configuration. You go under designs. You, while developing your invention, while going ahead with the project, have created certain drawings, maps, charts, get it protected under Copyright Act. So that is how you at least secure the drawings. It may so happen that you complete your invention work within 2 years, and within those 2 years somebody has got the hold upon your diagrams and maps and charts, and on the basis of that it has helped the other companies or your competitor to springboard and develop a competing product in the market. So at least if you have a copyright registered over your maps and charts, you can secure your rights and stop your competitors in the market. So once these IP components are identified and are developed into workable assets on property, as I said, you must get it registered under the respective heads of the IP law. Design Act, maps, diagrams, chart under Copyright Act, and keep the tab upon the progressing inventions and consult the in-house IP manager, facilitator of IP attorney to assist in identifying the IPs. This will also help you out that you may, while initiating your project work, think that your proposed idea or invention will go in XYZ direction or in this particular direction. But during that process, it may so happen that you are lost. You don't know where you are going. So at that time, consultation with a facilitator or an IP manager or an IP attorney will guide you where and in which direction you must now shift your focus in order to have a protectable intellectual property at the end. What are the other aspects? Now, we have talked much about IP, the basic components of IP, which one must keep in mind before going ahead with the project. But if you are a student, uh, if you are an administrator of the college, if you are a principal of the college, if you are an administration of the college, you must have a legally enforceable non-disclosure agreement with the inventor or the student or the professor or XYZ. Anybody who's working on the project, they all must sign an NDA agreement so that later on, uh, in case if it is divulged by any party to XYZ person or a third party, you may have some right at least, to secure the financial needs which has been invested so far, and you can get the damages by enforcing those non-disclosure agreements. The universities, colleges, and institution must make IPR policies, and I really hope that already under the national IPR policy and all these activities which are being done in India, now the universities and colleges are very much upfront, and they must have created their IPR policies well in place, under which the project by the student or the young innovators can be done, and the rights over the such inventions has to be defined. As I earlier said, it is very important to know that what technology already exists, so that you don't end up wasting time and money for something that already exists. You may tie up with industry chambers. Very reputed and big chamber of commerce are there in India. You can associate and tie up with them to identify what the problems are being faced in the industry and take it up as an innovation project. Now there is a very new term called spin-off companies, which I don't know whether everybody hearing this are aware or not. But there is a system called spin-off companies wherein the university and the stakeholders of the university or the research team of the university, they establish altogether a company under the Companies Act, and the research work which they feel will generate some intellectual property. That research work is, when developed and when it is in a tangible form, it is then transferred to such spin-off companies, which are made by the university itself. These spin-off companies, they work as technology transfer entities. What these companies do is they tie up with some industry person and they apply this research project or your invention and make it workable under the industry standard, so that you can have a final approved and good product. Because ultimately, if you get a patent, it is very much necessary that it is workable in the industry, because if your invention is not workable, your patent can be revoked. Just by securing a patent, it is not enough. It should be made use of in the market. What are the other IP components? As I said, the name of the product, if you have thought upon like something, you may have named your product or process, you trademark. The diagrams, figures, pictures, and plans can be copyrighted. The 3D configuration and pattern can be protected under the Design Act, and software and computer related inventions must be checked for copyleft. Now it is interesting, you must check whether the license agreement of this open source software allows you to use it in this particular manner or not. Because if you do not read those license agreements while developing, generally, if I may say that this mistake everybody does, including me, we download certain applications on our phone, we click agree to all, and we install and download it in our mobile phones or computers. So we do not have much time to read through all the terms and conditions, but those terms and conditions are very much important to be read, especially when you are an innovator and when you are an inventor with regards to technological innovations, especially software inventions. So you must read that the open source software which you are using whether it allows you to use it or not. And if it does, then are there any terms and conditions with regards to royalty or not? Because once you have developed your software on the platform of open source software, and if you launch your product in the market, later on you may receive a legal notice from the said person who owned the open source software, and he may ask a huge amount of royalty from you because you have developed your software on the basis of that open source software. So this is very important component which the innovators must keep in mind. Now, just to give a gist of how this entire talk, uh, which in fact even I would have been privileged if somebody would have explained me during my curriculum days or my research days, it would have helped me. A very good example of Groove Shark. This was a company, basically a startup, which did not check about copyrights and licensing. It streamed 5,000 songs on its website, and ultimately it so happened that those 5,000 songs were already copyrighted by somebody, and these people, the Groove Shark did not secure any license from them before using those songs on their website, and they had to pay a huge sum of $150,000 as damages because their use was unauthorized. They did not secure proper permission. So it is very important that you must, when you use already known technology of someone else, you must secure certain licenses and permission from the person before going ahead with the project. Otherwise, your venture may fail ultimately. It is a very important thing which should be kept in mind. So that company went bankrupt and it was closed for this reason. Now suppose your research work includes and develops something, a very good product which has a substantial IP into it, and your company does not work eventually. So your IP is such an asset which can help you out in gathering the finance, and this is what happened with this startup company. It was defunct, but by selling its intellectual property, eventually it could gather large amount of money out of it. A very good example of Kodak company. We all must have used the old cameras of Kodak, but now we do not see this company in the market anymore. It went bankrupt, but it could raise $525 million by selling its intellectual property. So you will be able to estimate what is the importance of IP in today's world. So these ring pull cans of Coca-Cola, I think everybody is aware of it. The inventor of this ring pull cans, the ring pull, earned 1 by 10th penny per can. So he licensed his invention to big soft drink company, and was when the patent was subsisting, he earned 1,48,000 UK pounds a day as royalty for his invention. Very good product of Mitti Cool. Mitti Cool is a trademark, as you can see. It may seem obvious, but using the soil to make a refrigerator, he got a patent for this. And this is very important that he got it patented in the initial days itself, which shows its importance. Big company like Starbucks had to, bend down on his knees because the trademark Duffin, which it was using, was already registered by a very small time cafeteria in London. So securing your rights, stitch in time always saves nine, as it is said. Again, a very small company called I4I, which had certain XML related patents, could stop a huge giant like Microsoft from infringing its patent, and it also received $290 million as damages, as Microsoft was infringing the patents of I4I. So very small company, as you can see, very small time innovators and inventors. They considered their IP to be very much significant. They got it protected, and see how they could secure it from big giants also. Well-known story of Kiran Majmudar started her company from a garage and has 1,200 patents today, 984 patents and 448 trademark registration. Queen of QVC, Laurie Grenier. It may seem very simple, but in 1996 she got it patent. She got a patent for her earring holder, and she has licensed this product to so many companies, and has helped her in securing so much money in the. So philanthropist Esther Dyson says that owning the intellectual property is like owning a land. You need to keep investing in it again and again to get a payoff. You can't simply sit back and collect rent. So I think I've tried my best to justify the title which was given to me, and I'm really thankful to the organizers and the MHRD and Pune College of Pharmacy for having me with you today. Thank you so much.
Didactic talk, you have really explained the concept of intellectual property rights.
Trade secret is there is no specified law with regards to this particular form of it is not an intellectual property basically, but very good example of trade secret is Coca-Cola. So suppose if Coca-Cola would have secured a patent over its formula or would have secured a copyright over its ingredients, so the limit that the time for those kind of IP is very limited. So today everybody would have been making Coca-Cola. So the started when they decided to keep it a trade secret. It is such kind foreseeable NDA contracts or other contracts. Even they cannot reveal those secrets to anybody. And if they do, they can go under the law of tort, which is again another branch of law, and a breach of contract suits against such person. That is how it is different from patent. And I'm sorry, what your next question was? I think.
Yes, like how long does the patent process like carried out?
Yes.
What's the duration?
Yes, the duration for patent process as per the act, if I would say, is that once you apply for a patent, it may take at least 3 to 4 years. That is the general practice because it takes time to examine the patent by the examiner and patent office. You have to meet with up with the objection. Then it is published. Then it may be possible to oppose your patent. So the hearings are done on that. And now the timelines have shrinked much. Earlier, it used to take 7 to 8 years, 3 or 4 years. The patents are being granted. So that is generally how much the time it takes in India, at least, to get a patent registered.
Okay. Can you name a few certification courses regarding
Where you can get the help.